Hello and welcome. I'm Chakshu Roy and you're watching Laws in the Making on Rajya Sabha TV. Today on the show, we are discussing the DNA Technology Use and Application Regulation Bill 2019. The DNA of a person is unique. It can be used to match individuals and identify them. DNA-based technology can be useful for criminal investigations, identification of victims and accidents, and parentage-related disputes. However, the use of DNA-based technology is not regulated. To discuss the issue, I have with me on the show Dr. Vikram Singh, former DGP, Uttar Pradesh, Dr.Anupama Raina, senior scientist at AIIMS, and Ms. Rekha Agarwal, advocate at the Supreme Court of India. The bill has been brought to regulate the use of DNA technology. The bill includes a schedule which specifies instances under which the use of DNA-based technology is applicable. The bill has provisions for storage of DNA data banks. Further, it establishes a regulatory board to supervise the functioning of DNA data banks and regulate the use of DNA-based technology.
Prior to introduction of the bill, a Law Commission report addressed certain concerns regarding privacy-related issues. The bill, under its provisions, includes mechanism for the removal of DNA data. DNA profiles in the crime scene index or missing persons index will be removed from DNA data banks on the basis of a written request by the individuals. The DNA profile of a suspect will be removed after filing a police report or as per a court order. In the case of an under trial, the DNA profile will be removed on the basis of a court order.
What used to happen so far is that self-incrimination as per Article 20 subclause 3 was declared to be unconstitutional as per this particular constitutional article. So now as per the DNA bill, because most of the times in case police investigating agencies used to collect any data which was supposed to be linked to the accused, it may be a blood sample, it may be a hair sample, it may be a semen sample, it was usually taken to be self-incriminatory and violative of somebody's fundamental right. Now with this bill, since for all serious offences there will be no mandatory requirement of consent. So for all those offences wherein there is no eyewitness for that matter, and for most of the heinous offences, usually there is no eyewitness. So definitely DNA bill will go to a large extent, or I would say a very long way, for helping investigating agencies in resolving, or I would say getting to the accused, or having an acquittal which would be fairly, I would say, affirmed by the appellate courts. That would be one. The second thing would be a lot of missing persons under the list. There are several indexes they are going to create. One is going to be for the suspected or for the criminal agencies for whom this is going to assist. One is going to be for the missing persons detail. So all those people or all those children for that matter, in India there is a data that every month more than 500 children are missing throughout the country. So there is going to be missing children detail index as well. So that's also going to assist the investigating authorities in coming to a conclusion and able to have a detailed investigation.
The bill establishes a DNA regulatory board, which is responsible for supervising the work of DNA data banks and DNA laboratories. The foremost task of the board is to ensure that profiles of individuals collected by DNA data banks and laboratories are kept confidential. Additionally, the board is required to make recommendations to the central government on privacy protection in relation to the use and analysis of DNA samples. The board will be headed by the Secretary of Department of Biotechnology. It will have experts, representatives from the NIA, CBI and NHRC as members.
All DNA data will be stored in regional data bank and then transferred to national data bank, where it is secured and nobody can misuse it further, and there are legal limits to retain it or removal it from the DNA data bank.
The bill denotes any unauthorized leakage of confidential information contained in DNA profiles of individuals as an offence. Any use of DNA sample without authorization is also declared as an offence. The penalty for these offences is imprisonment up to 3 years and fine of up to 1 lakh rupees. The penalty for intentional tampering or destruction of biological evidence is imprisonment up to 5 years as well as fine up to 2 lakh rupees.
The DNA technology bill was introduced in Lok Sabha in this budget session of Parliament. But this is not the first time this bill has been introduced in Parliament. It was introduced in the previous Lok Sabha. It was passed by the Lok Sabha, but it lapsed after the dissolution of the Lok Sabha. Dr. Raina, I wanted to start the program with you, and I wanted to ask you what has been the journey for DNA profiling in our country, and also what is the journey of the legislation that regulates DNA profile in India?
In respect to the DNA, this technology in India, it started long time back in 1994 when AIIMS, under the leadership of Professor Dogra and Dr. Hasnain from SIS, National Institute of Immunology, we did one of the criminal cases. So it started from there in India when it was in the infant stage at India. We did with a single locus PCR technique. Though Dr. Alex Jeffries, he started it with the multi-locus probe, but with the advent of the time and the technology, we came up with the single locus probe, then the single locus PCR. Now, as on date, in India, the labs are as good as we have the labs in US or UK, with the latest and updated technologies. To identify an individual, we do the STR markers. These are the short tandem random markers, which are found very abundant in the human genome, and which helps us a lot to identify an individual. Now, regarding this bill, this has been drafted, this is being drafted since long time, maybe more than 5 or maybe 7 years. And it started by a committee which was organized by the DBT, and the meetings were held at CDFG Hyderabad, and it took pretty long time to come to the Lok Sabha.
Dr. Singh, you've been, at the forefront of criminal investigation and policing. You were DGP of Uttar Pradesh. I wanted to understand from you, so what is the need, for having a bill like this?
Mr. Roy, this is an excellent piece of legislation, and we joined the League of 60 advanced countries, and that would include the top countries who have used this technology and used it not only in criminal jurisprudence but also in social service, like identifying dead bodies, identifying missing persons, and in matters pertaining to paternity issues, surrogacy, medical termination of pregnancy, etc. Now, if there is anything that is infallible in a court of law, I would say that the DNA technology and the DNA footprints are the infallible evidence that is infallible, incontrovertible, and indeed in matters pertaining to all crimes that are body offences and not necessarily body, wherever there is a paternity and wherever there is the issue in respect of a person's identification, the far-reaching consequences that any technology will be a force multiplier, it is the DNA technology only. There are issues, and there will be issues when you introduce something which is state-of-the-art and futuristic. But in this case, I would say that it will be the game changer as far as criminal investigation is concerned and conviction rate is concerned, and to that extent, this will be a tremendous service to society and the nation.
Okay. Rekha ji, one of the things that people are talking about is, how will DNA technology be used and what will be the, locus for evidence in courts? So what has been happening in our judicial system till now when we need to identify individuals, and how will this bill change that?
I think this is going to be a very big landmark bill, and ultimately it is going to be very helpful in deciding both civil and criminal matters, because I think the primary concern in any matter, whether it is a civil or criminal matter, is the proof. We need evidence for any case to proceed further, because the first thing that the guilty person does is, whether it is a civil dispute or a criminal dispute, is deny his identity or the identity of somebody else who is claiming something. So what we have in the Indian Evidence Act is what is called primary evidence, and if the DNA bill ultimately succeeds in passing certain laws which will make it practical to establish the identity either of a victim or of an offender. In both the cases, whether it is a criminal matter where the identity of a person is very important, and even in civil matters, for example, where there is a property dispute where the parentage is being denied, or very recently we had the famous case of N.D. Tiwari, where the limelight was there on whether his son was his biological son or not. So these things can be taken as primary evidence in the court of law if there is a finding that the DNA of the victim or the offender matches with what is being claimed by the prosecution or by the other side. So for any case to take off and for the trial to effectively conclude What we require is what we call in Hindi saboot, proof. The proof is missing, and if the identity of a person can be established by taking the DNA, and that is of course with the consent of both the persons, of the victim and of the offender, unless the punishment of such a case is beyond 7 years of imprisonment for death, no permission is required for such kind of cases. And if the DNA is established, then I think that the trial can effectively conclude and nobody can doubt his or her identity, whether of the victim or of the offender.
Dr. Raina, you have been at the forefront of using DNA technology when it comes to criminal cases. Can you shed a little bit of light as to how does the technology work and how has it been used so far in the country?
This technology, we consider it as a very powerful technology in the field of forensics. Because one of the main reasons when we identify an individual is this technique is based on Mendelian law of inheritance, which says 50% of the genes from the biological father and 50% of the genes from the biological mother. So this technology has helped a lot in many cases in India where I have been associated. Like first case which was taken up by me, the criminal case in India was one which was forwarded by the Human Rights Commission, when a lady who was, when she was going under trials, she conceived and her husband alleged for the jailer. But DNA technology, it proved that no, it's not the jailer, but it is the husband who is the father of the child. And likewise, I have done many cases of the national importance, like Kashmir Shopian cases, in Godram train carnage case, in Nithari the serial killings. So it has helped a lot in identifying an individual with 100% accuracy.
Okay, Dr. Singh, Dr. Raina talked about forensics. And forensics is an important aspect of criminal investigation. So what have we used, in the absence of DNA technology, what are the kind of forensics that we've used in establishing the identity of individuals currently in our criminal investigations?
That is a very basic and almost Victorian level of investigation that we use circumstantial evidence that is known as Paristhiti Janya Sakshya. And that of course has its own flaws, though yes, it is quite convincing, but nothing to beat. In a scale of 1:10. Other circumstantial evidence would stand at 3 out of 10 and DNA profiling would stand at 10 out of 10. This is the level of difference between DNA and other circumstantial evidence. I'll give you the example of Napoleon. It was rumored that he died of this and he died of that, he died of old age. But the fact remains that it was only after that this advanced technology came, it was said Napoleon died of arsenic poisoning. And this is the wonder and this is the beauty of technology and DNA profiling, that you can get to things not today, not tomorrow, but even after. Napoleon died in 1815 and today you are able to identify exact cause of death of a person who died hundreds of years ago. Similarly, in this case, any body offense would presuppose interaction of body fluids, whether it's rape, whether it's murder, some hair strand, some sputum, some body fluid, some discharge, that can be collected by a skillful investigator, sent for chemical examination and forensic examination, and I'm sure the results is going to be something that will be a game changer, and the court cannot ignore the evidence produced by a skillful investigator.
Ms. Agarwal, if I can have, your comments about, use of fingerprint as evidence, current use of DNA as evidence. You mentioned the ND Tiwari case. How was, parentage established in that case? Can you shed a little bit of light on that?
Yes, as I just said in my earlier comment on the DNA bill, that in any case, whether it is a civil case or a criminal case, the first thing that one requires to take the case to its logical conclusion is proof. And the first thing that any offender does in any such matter is deny his total liability. So even in the case, for example, I mentioned about ND Tiwari, the immediate reaction of the human being is to say no, that let time prevail, and as time lapses, maybe I will be able to get out of it, maybe the case will die its own death. But after a great deal of reluctance, when Mr. Tiwari agreed for his DNA sampling, then the son who claimed, Rohit, who claimed to be his biological son, was able to prove and vindicate his stand that yes, he was indeed the biological son. So similarly, what as I said is, since we require primary evidence for any case to be taken to its logical end, therefore just like fingerprinting is required to establish the identity, like in Aadhaar card, now that the Aadhaar card have become redundant after the new budget, but in every such case, when we try to establish the identity, we try to take the fingerprints, we try to take the eyeball indexing, and now DNA, as Mr. Vikram said, that this is the state of the art. This is going to be a total game changer. And once the DNA of either side is proved, that will be taken as the primary logical conclusion for deciding of a case.
Great. It's time for us to head into a break. When we come back, we will discuss the different provisions under the bill. Welcome back. On the program today, we are discussing the DNA Technology Use and Application Bill 2019. The bill provides for the regulation of the use of DNA technology for establishing the identity of a person. A similar bill was introduced in the 16th Lok Sabha but lapsed on its dissolution.
The bill contains a schedule which lists matters for which DNA testing can be used for identification. This includes offence under Indian Penal Code 1860 as well as offences under other laws such as Immoral Traffic Prevention Act 1956, the Medical Termination of Pregnancy Act 1971, the Protection of Civil Rights Act 1955 and the Motor Vehicle Act 1988. The schedule also allows for DNA testing in certain civil matters. This includes matters such as parentage dispute, immigration or emigration, and transplantation of human organs.
DNA test has been a very revolutionary for solving the crime, and it is one of the very clinching evidence where it's very specific and very accurate. So we have been using this DNA technology as an evidence in the court of law to convict, especially in the sexual assault cases and also in some violent crime cases where the DNA of the accused is matched with the biological stain in the scene of crime. So it is a very accurate and very specific evidence where many criminal has been convicted. Number two, if the government regulates that they will keep a data of the DNA profile of all the criminal convicts, this data will be very helpful in case of any crime in the society to rule out these convicts whether they have committed the crime again, because 70 to 60% of the cases, as per the study, has shown that these are repeat offenders. We must have seen the serial killers, serial rape accused. So this DNA data of the criminals, it will really help in narrowing down the convicts to solve the cases by the investigating officers. So it's a great help for criminal investigation.
In the event an individual is suspected of an offence that carries less than 7 years of imprisonment, his written consent to collect his DNA sample is required. If the offence carries punishment of more than 7 years of imprisonment or death, consent is not required. If a person is a victim or relative of a missing person, authorities are required to obtain their written consent to collect bodily substances. In case of a minor or disabled person, the written consent of the parent or guardian is required.
There is a special provision under this act. For example, somebody who is just a suspect, and let us say what we were discussing about the offence is punishable beyond 7 years, so his consent is not required. So in case his DNA is collected and later on during the investigation, if he is acquitted, he can definitely move an application to the respective court or to the DNA regulatory board. There is going to be a DNA regulatory board who is going to supervise the DNA banks. So that person can move an application to the DNA regulatory board or to the respective court in removing his name, and that name can definitely be removed. Or for anyone for that matter whose DNA has been taken against the law or the relevant provision, he can move an application and his respective details can be removed from the DNA bank.
Any laboratory that conducts DNA testing will have to obtain accreditation from DNA Regulatory Board. These DNA laboratories will have to share this data with DNA banks established at national level and in each state. Each data bank is obliged to maintain indices that categorize DNA data according to specific categories in the bill. These categories include Crime Scene Index, Suspects or Under Trial Index, Offenders Index, Missing Persons Index, and Unknown Deceased Persons Index.
Dr. Raina, you've been analyzing DNA data, and one of the things that the bill is doing is establishing DNA data banks, both at the state level and at the national level, for storing DNA data. Can you tell us a little bit about how DNA data or DNA profile data is stored?
See, as on date, it's very easy to store these data because everything is computerized. You have DNA automated sequencer which has a computer with it. You have the USBs. It's very easy to store. You don't have to store it. The earlier times you used to have a store in the files and pile up the files in a cupboard. Now it's not like that. You can have a store of a DNA of a person which does not change at all throughout the life. So once a DNA fingerprint obtained of a person remains same throughout the year, any biological fluid used gives this the same DNA pattern of a person. So it's very easy to store these data as on date. Maybe now we can store it, then share it at the regional level or the national level.
Okay. Dr. Singh, so clearly storage of the data is easier. The bill is also talking about creating 5 different types of indexes for collecting this data and storing this data. Can you talk a little bit about that?
That is with great application of mind and very, very functional. First, the scene of crime index. Number 2, the offenders or the accused. The third is the accused. The fourth is the missing persons, and the fifth is unidentified dead bodies. Nothing could be more suitably and scientifically compartmentalized than these 5 chambers, and this would make things so very functional. Now, in case of, we have almost 4,000 unidentified dead bodies being recovered. As some of the speakers said just now, 500 children go missing every day. And that is the reason why it is not an option, it is a compulsion to have these 5 indices, and they will make things so very functional that at the press of a button, the regional or the central data bank will provide you the necessary details, because on one hand, you have the access to the DNA from the scene of crime. On the other hand, you have the access to the data bank. Just imagine the most sensational murder case that happened in the NCR in 2008. If this technology had been there, if the dead body had been shifted from place A to place B, you would have got the results not till the end of eternity, but at the flash of a button. Secondly, if there was a body fluid inside the deceased, you could have got the results too. That was a game changer. I wish we had this technology in 2008.
Okay. Rekha, one of the things that people are talking about is what are the kind of safeguards that are there in the bill for collection of DNA data, let's say from the accused. And earlier part of the program, you were mentioning that there is a certain type of offences for which you need to require permission, for which you don't require permission. Can you talk about that?
Yeah, I'll just clarify on this that if the offence carries a punishment of 7 years or more, or even with death sentence, then in such cases the permission of the accused person is not required before collecting his DNA sample. However, in all other cases where the punishment is less than 7 years, then the permission of the accused is required before his DNA sample can be collected. And in civil matters also, the permission is required. It cannot be taken without the consent of the person, because see, what is most important, as I said in my earlier comments, is the requirement of proof beyond reasonable doubt to convict a person in a criminal offence. And very often we see that cases where the person is acquitted because the prosecution has not been able to prove a case beyond reasonable doubt. The benefit of doubt is given. But now that this DNA bill is going to see the light of the day, we can definitely see such cases where a person just walks away literally with murder, that the person is going to be nailed if the DNA is collected in time.
Dr.
There's
Singh,
also a very interesting development. You have cases where people volunteer to give the DNA samples just to say that they were not involved in a crime, and this is the beauty of the DNA technology, that you can either be proved innocent also through an absolute application and proper scientific application of this technology.
Okay. Dr. Raina, you were talking earlier about DNA data banks. You were nodding, when Dr. Singh was making his intervention. What is the kind of regulatory mechanism that exists in the bill for regulating data banks? Because clearly these data banks and these laboratories will not only be, in the government space. There will also be private players who will be involved in that. So you talk about that?
Well, in government laboratories, see, we are sure that as on date, it's very essential to have a bill because each laboratory has its own protocols. But once it is regularized, we'll have the same protocol, although there are many methods which we follow the same in all the laboratories. But once we have it regularized, and it becomes easy then to share the data bank once you are using the same kit throughout all the labs, maybe at the regional level, or maybe at the state level, or maybe at the national level. So it becomes easy to share the data with each other. Like I give an example, like in Nithari murder case, I just take a second. We finished that case maybe in 2 months or 3 months, but we had some claimants even after 8 months, 9 months. But since we had the DNA of the case, we could match them and give our report.
Okay, perfect. So we almost at the end of the show. Can I just request all of you for your final comments about what will be the impact of this bill in different spheres of criminal jurisprudence and civil jurisprudence? Dr. Singh, I want to start with you.
This technology and the bill will have far-reaching positive consequences not only for the police and the investigators, but for the public and for the nation. We can also identify the illegal migrants, that the problem that we have at hand, and the story has just opened, and there are indeed very positive possibilities and potential in this bill and in this technology.
Rekha?
I see a very quick and final disposal of all cases, particularly criminal cases, and nobody can get away with murder by denying his identity or doing away with the evidence, doing away with the victim. So there is going to be a positive final closure to criminal cases particularly.
Thank you. Dr.
Finally, yes, this bill is going to help a lot because there are many criminals who keep committing crime in one place, then they move to the other place. But once we have a data bank to share it, we can come to the conclusion.
Thank you all of you for joining us on this discussion. It's time for us to end the show. You can watch our shows on the RSTV page of YouTube. We will be back with a new issue and a new episode. Keep watching Rajya Sabha TV.